vacate that
I mean,
final
it is a
judgment.
pretty awkward rule to say that a jurisdictional defect, the remedy for it depends upon prejudice in a particular showing. And again, we didn't do that in lexicon.
Well, I'll try one more time. There's no jurisdictional defect here once you get rid of the dismissed defendant.
I understand your point.
Right. And so the question is, if the error was separating these claims against the two different defendants, what is the remedy for that error? That's really what the error was here.
But you're treating it as, we separated two defendants improperly. But in fact, from the plaintiff's point of view, the thing that went wrong is that the plaintiff is the master of her complaint. She clearly structured a suit in order to bring it in state court. That was why she joined these two parties, perfectly legitimately, in order to have the suit in state court rather than in federal court where it was. And the effect of this district court misjudgment was not that two parties were separated, is that the suit was tried in the wrong place from the plaintiff's point of view. And the plaintiff's point of view is the thing that should matter, because the plaintiff is the master of her complaint.
So I'll say a couple of things. It is true that the plaintiff is the master of her complaint, but that isn't a jurisdictional principle. That's sort of an overarching principle that guides federal.
It's an overarching principle of how litigation should work, and it also has a kind of equitable dimension, that you've deprived the plaintiff of an opportunity to do what our civil procedure system generally allows.
Yes, and exactly that argument was made in Caterpillar, and this court said that's an important principle, the plaintiff is the master of her complaint, but when you litigate a case to final judgment, it can be overridden by other principles of finality, efficiency, and economy.
Right. Now, that was a case where the court was absolutely certain that there was jurisdiction at the time of final judgment. And here, there remains a question about whether there was jurisdiction at the time of final judgment.
No question in my mind.
Given the fact that that Whole Foods is lurking out there, ready to come back into the case if the district court got it wrong, as it did.
Well, again, I'd say to be a party in a case, you have to be under the district court has to exercise jurisdiction against you. And that never happened here. The district court made a prediction about what it thought state courts would do with the claims against Whole Foods and said, I don't think there's a valid claim, and dismissed. Right? The plaintiffs can, in most cases, can then go pursue those claims in the state court if they wish. There's never any exercise of federal jurisdiction over that non-diverse defendant. And so then the whole case proceeds between completely diverse parties, including the entry of final judgment. So I don't think there's a real question about whether, the way this court has phrased it is whether the district court would have had jurisdiction over the case in the form it took at the time of final judgment. And there's really no question that that certainly was true here, that the district court had jurisdiction over the case in the form it took at final judgment. And again, if you view Whole Foods as having lurked through the case the whole time, then you really couldn't ever have fraudulent joinder removal, because there would never be jurisdiction to enter final judgment until the dismissal of that non-diverse defendant was later affirmed on appeal.
Couldn't it be affirmed